One of the reasons why you watch the Four Boxes Diner is not just to make sure you're the smartest person in the room to make the right arguments and know the right stuff. It's also to make sure you don't mistakes and say the wrong things. Well, guess who has not been watching the Four Boxes Diner Second Amendment channel here on YouTube? That would be the United States government. Because believe it or not, the United States government, the Department of Justice, has just argued in a major federal court filing that the fact that the English disarmed Catholics is a basis to disarm Americans from our right to keep and bear arms. Stay tuned. You're not going to want to miss this argument when we get back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gunner, constitutional attorney, member of the United States Supreme Court Bar, and author of First the King for the Gun Owners, the guide about how the anti-gunners intend to take our gun rights away, step by step at the retail level, at the wholesale level, and beyond. Check it out if you want to know what the enemy's got planned for us and how we can stop them. First, they came for the gun owners. All right, folks, so down in the United States District Court for the Southern District of Alabama, in a case involving whether or not an individual can be permanently deprived of his right to keep and bear arms for the rest of his life because of prior felony convictions, there's a fight about what the Second Amendment means and whether or not he can be disarmed for life. And what is the United States Department of Justice under Merrick Garland filed? Well, I'm going to submit a copy of this brief that they filed in opposition to a motion to dismiss the indictment under Federal Statute 18 U.S.C. 922 G1, that is the prohibited person statute. The Department of Justice is arguing that because the Second Amendment's right to keep and bear arms descends from the 1689 English Declaration of Rights that says you have a right to keep and bear arms in England unless you're a Catholic, the fact that it descends allows the government to make decisions about who can and cannot have guns. In other words, the Department of Justice argument, which I'll put a link to it down below, is essentially arguing that because our English predecessors, who we fought a revolution against and kicked out of our country in the American Revolution, or perhaps you could argue the First American Civil War, because those English, including the King, King George III, said that Catholics could not have arms in the same way the Protestants could have arms, we Americans, as the government deems appropriate and fit, can be viewed as Catholics under the Old English reign and be denied our right to keep and bear arms in the same way that the King denied Catholics the right to keep and bear arms. Now, this is absolutely wrong for a whole host of reasons. But before we get into the specific reasons why this is wrong, it is interesting that the Department of Justice, with their I think their budget is something like $40 billion, with a B, $40 billion, some number like that, some astronomical number. This is the kind of best argument they can come up with to deny people the right to keep and bear arms, is to rely on a 1689 law, the English Declaration of Rights, that expressly discriminated against Catholics in terms of who had the right to keep and bear arms in England, which is not even our country. We're the United States. We're not England. Nevertheless, let's carry on. You see, anyone that knows a little bit of history understands that, yes, it's true that at the start of our founding, we did indeed adopt a lot of laws from the English. But we were far more pro-freedom and far more anti-king, surprise, surprise, than the English were, which is why we kicked the king, King George III, out the wall, kicked him out the window, right? Goodbye. We got rid of the king, and we adopted some parts of English law, but we expanded English law in favor of freedom. So yes, it is true that in 1689, the English Declaration of Rights said that Protestants had the right to keep and bear arms, but not the Catholics, and we did indeed inherit that concept here in the United States, but we expanded the right to keep and bear arms to all of the people. Now, how do we know this? Look at the text of the Second Amendment. It says the right of the people to keep and bear arms shall not be infringed. That would be all of the people, not just Protestants, not just Catholics, not just some of the people, but all of the people. That's why the word people appears in multiple places in the Bill of Rights, including, of course, the Second Amendment, because it involves all of the people, not just Catholics, not just Protestants, and so on. Nevertheless, the Department of Justice is arguing exactly this, that because the English could say that Catholics could not have guns, the American government today can also discriminate against people they view to be inappropriate, not law-abiding, not well-respected, not responsible, whatever you want it to be. But they're basically saying that the government has the authority to cut back as to who among the people has the right to keep and bear arms. And they're using this English law as a basis for doing so. But that's not allowed because, again, if you look at the history here, as the Supreme Court has done, it is crystal clear that although that 1689 English Declaration of Rights can be a basis for saying there's a right to keep and bear arms, it's individual in nature, it is not a basis for allowing discrimination against groups in America in terms of the right to keep and bear arms. Specifically, keep in mind that the English Declaration of Rights expressly extended only to Protestants, but the Second Amendment extends to all people regardless of their religion. One reason why it's distinguished. The second reason, of course, is we're a separate country. We respect freedom far more than the English. That's why we got rid of the king, and they still have a king even to this day. The third thing is the famous commentator, early law professor, St. George Tucker, a very well-respected commentator relied upon by the U.S. Supreme Court in many cases. He was an American law professor, I believe, out of Virginia. He was also an early judge. This is what he had to say about the Second Amendment. And he talked specifically about how that it is broader than the English Declaration of Rights. St. George Tucker says that a well-regulated militia, being necessary to the security of the free state, the right of the people to keep and bear arms shall not be infringed. He said this may be considered as the true palladium of liberty. The right of self-defense is the first law of nature. In most governments, it has been the study of rulers to confine this right within the narrowest limits possible. Wherever standing armies are kept up and the right of the people to keep and bear arms is under any color or pretext whatsoever prohibited, liberty, if not already annihilated, is on the brink of destruction. That's not the Four Boxes Diner. That is St. George Tucker, an early American commentator from the founding era that the Supreme Court has repeatedly relied on as a go-to source and credible source for what the Second Amendment and the Constitution means. St. George Tucker, the law professor and judge at the time of the founding, went on to say this about the Second Amendment. In England, the people have been disarmed generally under the specious pretext of preserving the game, a never-failing lure to bring over the landed aristocracy to support any measure under that mask, though calculated for very different purposes. And here's the key thing about the Catholics and the use by the Department of Justice of the Catholic discrimination laws in England to disarm Americans. This is what St. George Tucker, the famous commentator the Supreme Court relies on, said. True it is, the English Bill of Rights seems at first view to counteract the policy, but the right to bear arms is confined to Protestants, and the words suitable to their condition and degree have been interpreted to authorize the prohibition of keeping a gun or other engine of the destruction of game to any farmer or inferior tradesman, so that one man in 500 can keep a gun in his house without being subject to a penalty. So here you have St. George Tucker trying to explain how the American system of the Second Amendment is the true palladium of liberty, in contrast to the English that are always looking for a way to take away gun rights. And now they basically have no gun rights today in the 21st century England. And certainly they use the excuse to disarm the Catholics, which St. George Tucker disagreed with and thought that was inappropriate and, of course, unacceptable under the Second Amendment, where all religions had the right to bear arms. But let us carry on. Another early founding era commentator, a 1791 attorney out of Pennsylvania that was appointed to be the district attorney for the state of Pennsylvania, a man named William Rawle, had this to say. Specifically, he says, in England, a country which boasts so much of its freedom, the right to bear arms was secured to Protestant subjects only on the Revolution of 1688. And it cautiously described that of bearing arms for their defense to suitable to their conditions and as allowed by law. Again, here you have another American commentator criticizing the English views, narrow views of the right to keep and bear arms and how it was restricted to just Protestants. Again, in addition to St. George Tucker, you also had William Rawle both criticizing the British for their narrow reading of the right to keep and bear arms, which they consider to be the true palladium of liberty, the foundation upon American liberty and human liberty. Both William Rawle and St. George Tucker. And of course, last but not least, you have the famous early Supreme Court justice, the youngest Supreme Court justice in history, I believe, Joseph Story. Joseph Story, you all know from the movie Amistad, the Steven Spielberg movie Amistad, where Joseph Story is the famous judge Supreme Court justice that freed the slaves that had overthrown their Spanish captors on the high seas in the ship called the Amistad, a very famous story that gave rise to the Steven Spielberg movie. And it was Joseph Story that believed in freedom so much that he freed these slaves and said they had a right to self-defense and to rebel against their slavers. And this is what he said about the Second Amendment. Joseph Story was a huge supporter of the right to bear arms. He's spoken about this repeatedly, but specifically as to distinguishing it from the English Declaration of Rights, which said only Protestants can have the benefit of the right to bear arms. This is what Supreme Court Justice Joseph Story said, quote, "A similar provision in favor of Protestants is to be found in the Bill of Rights of 1688, it being declared that the subjects which are Protestants may have arms for the defense suitable to their condition and as allowed by law." But he goes on to say, again, another early American commentator criticizing the English Declaration of Rights for not respecting the rights of the Catholics to have firearms. He goes on to say, but under various pretenses, the effect of this Bill of Rights provision or this right to keep and bear arms provision in England has been greatly narrowed, and it is at present in England more nominal than real as a defensive privilege. Again, repeatedly, you have founding era people in the United States criticizing the Britain and saying that their narrow right to keep and bear arms has some sway, but it is not the American right. It is not the same as the Second Amendment right, which we view to be much broader and more protective than anything the English had ever done. And I'm happy to report, by the way, that it's not just the early American founders that will take this argument from Merrick Garland's Department of Justice, trying to embrace discrimination against Catholics as a basis for taking away the right to keep and bear arms from people like us, including Mr. Jackson, where there's a fight again about the constitutionality of 18 U.S.C. 922 G1, and this is where this fight is occurring over whether or not this Catholic historical analog is appropriate. Do not forget, a couple years ago, the U.S. Supreme Court decision Espinoza versus Montana. Now, Espinoza versus Montana was a First Amendment case involving the religious freedoms. It involved whether or not a state government could ban giving money to students who could then use that money for religious schools. And prevented that money from going to religious-oriented schools. They could use it for any other school, but not religious-oriented schools, and whether or not that violated the First Amendment's religion clauses. And the Supreme Court says that that did indeed violate the First Amendment. The reason why it's significant in this context is for two reasons. One is that Chief Justice John Roberts and the Supreme Court went to what year to interpret the First Amendment? They went to 1791. And what year did they not use? The late 19th century. And this is very important because in the Espinoza case, as you know, a lot of the anti-gunners want to use that post-Civil War era because there's a lot more gun control laws there to justify modern-day gun control laws. So they want to talk about the post-Civil War era because there's more gun control laws, among other reasons, because they wanted to discriminate against the freed slaves and have gun control. Keep in mind, in the late 19th century, Justice Roberts said in Espinoza, there were 30 states. 30 states, including Montana, had no aid provisions to religious schools. And that alone could not establish an early American tradition because you had to go back to the founding. So that's very good on that point. But the more important point with respect to the Catholics is this, that the Supreme Court rejected those 30 state laws in the late 19th century. Why? Because they were based in bigotry against, you guessed it, Catholics. That's right. The Supreme Court said in Espinoza, in rejecting these laws that prevented the state funding of religious schools, and it said, quote, "It was an open secret that sectarian was code for Catholic. The Blaine Amendment was born of bigotry and arose at a time of pervasive hostility to the Catholic Church and to Catholics in general. Many of its state counterparts have a similarly shameful pedigree." And he goes on to say, the no-aid provisions of the 19th century hardly evince a tradition that should inform our understanding of the First Amendment's free exercise clause, which of course was adopted in 1791, over 100 years earlier. So to summarize, just to show you how the U.S. Department of Justice is on thin ice in justifying so many of the federal gun control laws, the fact that a U.S. attorney in Alabama would trot out these laws that discriminate on the basis of religion against Catholics, to justify the constitutionality of 18 U.S.C. 922 G1 in the case of United States of America versus, Anthony Lee Jackson, just tells you how far we, so far, knock on wood, have come in the Second Amendment community to advancing our right to keep and bear arms and protecting it from government overreach. And the fact that they use the Catholics is quite shocking because of, again, the history of not just the founding era that I just went over, but also that the U.S. Supreme Court, with Chief Justice John Roberts, has specifically rejected anti-Catholic laws as speaking to any kind of a tradition or narrowing scope or narrowing function of any aspect of the Bill of Rights, including but not limited to the First Amendment. And in this case, the Second Amendment is a little shocking the Department of Justice would go down this path. Nevertheless, this is an argument they're making. They're trying to use this as a basis to justify 922G1, which, of course, as you know, is the prohibited person statute in the United States Code, the criminal code. All right, folks, hope you learned a little bit something. If you haven't subscribed to the Four Boxes Diner, please do so. Don't forget to check me out on X or Twitter at Four Boxes Diner, and we'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.